Good morning, everyone. Thank you for joining us. My name is Deb Fewster. I'm the Director of Policy and Advocacy at the Victorian Council of Social Service, or as many of you know us by our more commonly used acronym, VCOS. I'd like to start by acknowledging the traditional owners of the land where I am today, the Wurundjeri people, and pay respects to elders past and present, to emerging leaders, and also to any First Nations people in our virtual room today. It is great to see so many people have registered for this event. So many people have joined us online in real time for what is our fourth Renters' Rights Rundown event for 2023. And we've been doing these for a few years now. And that's because we know it's really important for community sector workers, the people on this call and your colleagues outside the virtual room today, to learn more about or to refresh your memory on Victoria's renting rules, which are set out in the Residential Tenancies Act 1997. Many of you will know that over 130 changes to the Act were introduced in March 2021. These changes are now in full effect and outline renters' rights in Victoria. So 130, that's a lot of kind of reform, a lot of change, not a lot of new rules to process. We also know that since those changes to the Act took effect, that ever increasing rents are a huge challenge for renters right now. And there's not a day that goes by without media and political discussion about renters and what protections are needed to ease the pressure that they currently face. That's why this event is so important today. We know that it can be hard to make sense of what protections are being explored and what's already in place. And so this session is focused on what protections are in place under the RTA around rent increases right now. The support that you, community sector workers, provide to renters has never been more important. So we really thank you for taking the time to attend the session today. And for many of you, thanks for attending these sessions regularly as well. We know that you hold a wealth of insights on issues that renters are facing on the ground. So before we introduce our special guest, our subject matter expert today, I do want to take a moment to get a sense of those issues. In a moment, you'll see a poll pop up on the screen. And we're just asking you to just answer a few questions about rent increases and the impact they have on renters that you support. So it shouldn't take you too long to complete that. We'd really appreciate your feedback. It helps kind of inform our understanding of what's happening on the ground and our advocacy to government as well. For those of you who might have already completed the poll, we'll move through it pretty quickly, or while you're completing it. I do actually just also want to take this moment as you're completing the poll to really reaffirm that VCOS is a proud supporter of the Indigenous voice to Parliament. We think this is going to be, we don't think we know it will be a significant and meaningful step in the right direction for all Aboriginal and Torres Strait Islander people. As many of you will know and appreciate, housing is an acute challenge facing Aboriginal people. Terribly, Aboriginal people are overrepresented in all the data on housing stress, precarious living arrangements and homelessness. And that's the root causes of that are systemic and kind of deep-seated, the long kind of lasting impacts of colonisation. So none of us in this room can solve those challenges alone, but there is something every single one of us can do to help drive meaningful change. And that's to vote yes on October 14. So really just, I think we can't be talking enough about this at the moment. So just really wanted to share VCOS's thoughts and perspectives on that and really encourage all of us to be having these conversations and helping turn out support for yes on October 14. Thank you. And this poll will still be up for a few more minutes and then we'll move into the guts of the conversation today. All right. And I'm just going to ask my colleagues if I think we're right to go. So thank you for sharing those insights. It is really hard, I know, for many of us to be kind of engaging with these issues and hearing about the challenges facing renters right now, but we're glad to present this session for you, as knowing what renters' rights are is the first step towards asserting them and creating a fair and safe rental market. So as you know, we've got a special guest with us today who almost needs no introduction. He's such a legend in the sector, and he'll be very known to you if you've attended one of these Renters' Rights Rundown events in the past, and that's Ben Cording. who's the lead community education lawyer at Tenants Victoria, which is just a fabulous and important kind of mainstay of the community sector in terms of being that strong voice for renters. After Ben takes us through the rent increase framework, we are going to have a Q&A session, questions and answers, and we've allocated plenty of time for your questions. In terms of how these Q&A sessions work, if you haven't been to one of these events before or you just need a refresher, essentially the way it works is that you can submit a question at any time through the Q&A box at the bottom of the Zoom window. Please use that Q&A box for the questions, not the chat box. The questions will be moderated, as we expect many of you to be kind of asking similar questions about similar topics. So we'll kind of aggregate some of those questions together where there are some common themes. Please note, as always, the panel won't be able to answer questions about individuals or specific individual circumstances. We will get through as many questions as possible. We might not get to them all. We'll take unanswered questions on notice, and we will absolutely follow them up for you and share the answers, not just with the person asking the question, but with all people who are registered for this event. And we'll also ask you to do one more quick survey at the end, a quick exit survey that will pop up in your browser at the end, so that you can help shape future events that we run. So thanks in advance for your input. So now let's get into it, and please join me in welcoming Ben Cording from Tenants Victoria. Thank you, Ben.
Thanks, Deb. It's a very nice introduction. Yeah, so look, I'll try and get through the material as quickly as we can because I'm sure people do have lots of questions. I'm located on the lands of the Yalukit Willam people and want to acknowledge elders past, present and emerging. Personally, I'm voting yes, but obviously I think everyone needs to make that decision. I guess the main thing is that it's an informed decision. It's a well-researched decision. It's not a politically swayed decision from what the media says. Do your own research, talk to people, be open, and above all, if I'm a very simple person, do what you think is loving. That's how I'd put it for me anyway. So I will share some slides. I believe these slides will be available to you as part of coming to these sessions. They're not intended to be a substitute for legal advice, but they're hopefully a good start. When I write these, I try to do them in a way that gives you an example of what the paperwork actually looks like, so you can sort of understand at what stages things happen, and when there's an opportunity to try and advocate and hopefully get better outcomes. For many of you that don't know, Tenants Victoria is a free community legal centre, but particularly I want to emphasise that if you're a community professional, you're always welcome to contact us through our organisational advice line. So you can just call this number here, say I'm from an organisation, and as long as you're helping a renter, that could be someone in a rooming house, caravan park, what's called a Part 4A dwelling, also SDAs, specialist disability accommodation, even SRSs, supported residential services, we can look at some of those issues. So yeah, you can contact there. You can also email us as well. So that's available, and you'll hopefully get through to a lawyer fairly quickly. And yeah, we're happy to talk about anything. Even if you think you know exactly how it works or you've got no idea, all of that's fine. We really want to help as much as we can. So first of all, rents are going up. I don't think anyone's surprised by that, but how much they're going up can be a little bit confusing. There's a lot of stories, there's a lot of different data sets out there. Why the rents are going up? Again, it's a very, very loaded question. So we've seen that the Reserve Bank has been consistently increasing and sort of finally has plateaued and sort of paused the mortgage increases. And there's questions about whether or not that's sort of being passed on, whether or not there's the vacancy rates a driving factor because of landlords leaving the market for all sorts of reasons as well. And there's a lot of media spin. There's a really great organisation called AHURI, which is the Australian Housing Research Institute, and there's some really good articles in there that have a lot of integrity, and probably is a good place to look at, because we actually do need to be informed a little bit about the politics of rent increases. And one of the major issues is that within this rent increase framework, it's actually on the renter to challenge the increase. So all the landlord has to do is send off the notice, and unless the renter does something, the increase will be effective. So it's not necessarily something that I always do during these presentations. I'm actually going to drop out of the presentation and then I'm going to reshare hopefully one of my screens that I can find here. One of the things that's measured is called the Consumer Price Index. This is just on the website. So if you look up CPI for Australia, this is the ABS website. And this is actually important data because one of the things that the notice of rent increase requires is to specify the method of increase. And this is actually the CPI, how it's tracked sort of over the last 10 years. You can see here when the pandemic hit, we actually got negative consumer price index. So the consumer price index is about how much everything costs. Does it get more and more expensive? So if you think that things have been getting more expensive through the pandemic, you can see here that at the peak in December 2022, the CPI hit 7.8%. It's extremely expensive. And then it sort of dropped down at the moment to about 6%. So in a notice of rent increase, if a rental provider specifies that they've used the CPI, they need to somehow identify the correct percentage at the right time. And why that's important is because it may actually have an impact on whether or not the notice is accurate, whether or not it follows a method. The CPI also breaks down into what various things cost. So you can see here rents have dramatically increased in the last year. Insurance, there's huge numbers of articles about insurance premiums going way through the roof. So there's a whole bunch of data there, which is actually incredibly useful for us in terms of looking at so rental price increases. You can again see the surge here. There are also really useful articles that you can have a look at that increase, like talk about vacancy rate. So for those that don't know, the vacancy rate is really how many houses are available on the market to be rented. And so when I'm ending my rental agreement, I need to start a new rental agreement. How many properties are there? And we've all heard many people say, I've turned up and there's 200 people turning up to the inspection. And again, you can see that there's this seasonal vacancy rate here, which compares for various states and the like. So I'd really encourage you to actually not be afraid of statistics. I myself am a bit of a data nerd. I'm not very good at it, but this is a question that we're talking about when we're talking about justifying rent increases, about whether or not the amount that the rental provider is increasing is justified. And that's foreign for lawyers, it's foreign for community workers, and real estate agents are really at a significant advantage when they have data sets themselves of information about how much something costs, and also they obviously have an influence on the market. So it's certainly worth being aware of in terms of when you're trying to do a challenge for a rent increase, to look at and think, well, is this actually reasonable? And a lot of renters won't know. Most people will just jump onto the internet, have a look at other properties. And so we'll talk a bit about some of the things that are included. So this is just some of our own data sets that we've had. This is a little bit older now, but the median rent sits about $420. And we had an increase of about 7% in metro, but regional Victoria has been dramatically impacted over the last few years in terms of sea changing, working from home, all sorts of other reasons may contribute to that. So certainly be aware that many of our brothers, sisters and family that are living in regional areas are really under a dramatic shift in the culture of availability of rental properties. So probably one of the biggest messages for renting a home and the rental increase framework is that there is no cap. There is no limit. So my rent might be $1,000 today and I could get a notice to increase it to $3,000, $4,000. Now that's probably ridiculous, but it makes the point is that if I as the renter do nothing, that rent increase will be effective if it is validly done. And when we use the word valid, what it means is that it's done all the things correct according to the law. So there's quite a specific framework that says, rental provider, you must do this and this and this. And if you don't, then the increase will not be effective. Or if I pay the extra money under that increase that I thought was valid, I can actually get that money back. And we'll talk a little bit about that in a moment. But the long and short of it is that it is up to the renter to take action to stop the increase. And if most renters do nothing, then the rents overall will be compared to each other for all the other people that also did nothing. Now, that's not to say that we blame renters. We know that all sorts of people for all sorts of reasons have genuine concerns about challenging a rent increase. People are scared. They're scared of not getting a reference. They're scared of looking like they can't afford it. They may get some sort of notice to vacate or think that they can get certain notices to vacate. One of the important things is that the no reason notice to vacate. So a landlord used to be able to give you 120 days and say, I want you to leave and I don't have to explain. That is now gone. There's also an end of initial fixed term notice. So it used to be an end of any fixed term. But once you've got through your first, usually 12-month fixed term contract, they can't use that notice anymore either. And in most rent increases, you're not going to get that increase until after your initial fixed term. So it is a bit safer for renters to do the challenge. There's also prohibitions on asking questions if you've had a dispute with your previous rental provider as well. Your new rental provider or prospective rental provider can't ask those questions too. So what are the requirements that a rental provider has to actually follow to increase the rent? Firstly, they have to use the correct form. There's a specific form that's published as part of the law, and they have to use that form. And if they don't, it won't be valid. I'll show you what that form looks like in a moment. They need to give you at least 60 days clear notice before the increases to take effect. So if they only gave you 58, that won't be valid. If they gave you 59, it won't be valid. But if they gave you 60 clear days before the rent increase takes effect, then that will be enough time. We sometimes, as lawyers, look at how it was sent. So did your client consent to being sent documents electronically? Was it put in the registered mail? There's no requirement for a notice of rent increase to be sent via registered mail. So that can be a bit of a factual dispute that sometimes VCAT, which is the Victorian Civil and Administrative Tribunal, will need to decide whether or not the actual letter was sent and received. Now, one of the big changes in the law when Deb spoke about the 130 changes was this quite subtle change that the notice of rent increase needs to specify the method by which the rental provider decided how much the rent would go up. So that's quite an important one, and I'll touch on that in a moment. Now, when you get a notice of rent increase, the renter only has 30 days within which they need to apply for a report. It's a free report from Consumer Affairs Victoria. It's called a rent assessment. And they will actually come out to the property and look at the property and say, okay, what does this look like? Is it in good repair? How much does it cost to provide? So pretty much that's an opportunity for the renter to show all the bad things in the property that might actually take away from the justification of the rental provider trying to increase it. If the renter's made any improvements, generally that's not something that should be considered to justify an increase. So certainly, yeah, it's a really important occasion to try and be there and actually walk through with that Consumer Affairs inspector, all of the aspects of the house that may not, be favourable in terms of saying, well, look, this property looks great on the outside, but inside, look at all the mold or whatever else it might be. So if the landlord doesn't do this increase correctly, following these things above here, then the increase won't be effective. Or if they've paid it, then you might be able to get compensation. So the impact of the rent increases is obviously dramatic. And over a period of time, this can actually add up to huge amounts of money. So many years ago, I had a client who had paid very low rent, and each year just got a little letter in the mail saying your rent's going up $100. And then we realized that there was no proper advice about being able to challenge it. It wasn't in the right form. And so it was invalid. And we did the maths, and it was almost about $40,000 worth. So that money adds up very significantly. And it's similarly, there's a decision here called Burgess and Seminole, which came through. And hopefully I won't get into trouble for this. But the landlord in this particular situation described the rent increase framework as, quote, legal bullshit. It was legal bullshit according to them. And after the renter identified their rights, started to get very edgy, wanted to evict the renter. And this decision is both good and bad. It raises a really significant concern in that the claim was probably about a $12,000 refund of all the money. And one of the issues that we're having at the moment as lawyers is that some VCAT members go, right, a refund is you get all your money back. That's what a refund is. You would expect that. Whereas some members, they're like the decision makers at VCAT, are saying, well, we think you are getting compensation for an ineffective rent increase, and that's subject to what's called an obligation to mitigate loss, which means, well, if you looked at what your rights were, you probably would have taken action in a few months, so you're only going to get $1,800. And you can see that the difference between $800 and 12 grand is huge. And that's a bit concerning. And until we get some guidance from the Supreme Court, we don't know. But either way, if you identify that a rent increase has not been done properly, or you think a rent increase has not been done properly, you can go and have a challenge. And there's different challenges. There's a validity challenge, which is saying you didn't follow the right process, and you can kind of do that at any time. And then there's the technical challenge in terms of the rent assessment. Is this going beyond how much the market should charge? So that's these are two probably fairly good cases to have a look at if you're really interested, but it just gives you a bit of a flavour of some of the challenges. So in this other matter, one of the reasons we also look at rent increases is that it can be a relevant issue to rent arrears. So when someone falls behind in their rent, we will go and look at the rent increase history to see whether or not it was done properly, because that might actually stop them being evicted. So in this Gregorio matter, there was an allegation of a lot of arrears. But when they looked at the rent increase history, they identified that, in fact, it hadn't been done properly, and it put the renter in a position where the notice that it was saying you owe this much rent arrears was significantly wrong. They didn't actually owe anywhere near that amount. It's about $4,000 difference. And so the tribunal said, I have to dismiss this application. So the Supreme Court's told VCAT, if the amount that's said to be owed is pretty wrong, we can't entertain that. It's not right. You've got to restart the process. So in two contexts, rent increases can be really important. One, about getting some money back if they didn't do it the right way. Also, it should always be looked at when you've got a client that's facing rent arrears. So you want to look at that rent increase history. So with this method of increase requirement, there was a notice to increase that said, we used a comparative market analysis as being the description to justify how much the rent increase went up. And VCAT said, well, actually, is that really a method to just say comparative market analysis? Because that sounds pretty fluffy. There's not a lot of detail behind that. And VCAT actually decided that that wasn't valid. It said that that's not good enough. You've got all this research. The tenant doesn't have that data. You can't just plonk a figure on there and use the phrase comparative market research to check the box. Not good enough. And so in this decision of Boyce and then the subsequent decision of Kennedy from VCAT, they both said there's got to be enough detail there for the renter to be able to look and say, yes, I see why that it's reached that figure. So it's a really important issue to look at whenever someone's talking about rent increases. So if that's been something that you come across for your clients, you see their rent increase notices, or you would say, hey, look, let's have a look at this, you may be able to actually able to claim back some of that money. There's similarly a little bit of confusion or lack of clarity about when you got an old rental contract and then you get offered a new rental contract and it's got an increased amount built into it. We believe, and I think that there's good law to suggest that they should still get a notice of rent increase, and you may be able to challenge it. Some people think that when you agree to that new agreement, you're saying, well, I'm accepting it, I'm not going to challenge it. But I think that there's a little bit of wiggle room there, so we'll have to see how that one goes. So when can your rents be increased? They can only be increased once every 12 months for most tenancies. The only exception to that is that if you've been on a periodic agreement since I think the 19th of June 2019, then you can actually get it every 6 months. But for the vast majority, as a general rule, you'd be thinking that they can only increase every 12 months. And for a lot of rental providers, that creates a lot of anxiety because who knows what the Reserve Bank's going to do in that time? Are they going to jack interest rates up? One of the big challenges as well with the rent increase framework is that when the Reserve Bank interest goes down, rents don't go down. So, that's not exactly a perfect system, is it? So I think that the important thing is that the agreement needs to specify the amount that's going to go up, and you really need to act quickly. They only have 30 days to apply for that challenge. So anytime the rent is increased, they need to be given this notice. That's probably one of the biggest take homes. So this is just a bit of a flow chart. The renter does nothing, and it's a valid increase, the rent will go up. You've got a 30-day window to do the challenge. Consumer Affairs will come out to look at the property. Now, when Consumer Affairs come out, they can negotiate to, say, hey, look, is there any wiggle room between the parties here? Now that you'll get a report back. It must be in writing, and I've got an example that I've made up in the slides for you. Now, the report will either say it's excessive or it's not excessive. In both situations, if the parties can't reach an agreement, they have to apply to VCAT. So they have to apply under Section 46. The application cost is $70.10. If the person's in financial hardship, which many of them might be, then they can ask for a fee waiver, and it's effectively free. So the report is free, going to VCAT is free. And if VCAT says, yes, it's excessive, then they can fix the rental amount for 12 months. There's really no situation where the landlord can turn around and go, oh, I'm going to give you a notice to vacate because you challenged. The main notices to vacate that we're seeing is that the rental provider is going to sell, the rental provider is going to move in, or they're going to do repairs and renovations. And in all of those situations, there's quite particular requirements now and tests that allow the renter to challenge. And there's also what's called a reasonable and proportionate test, which is about, is it really justified to get the renter out? And there's some criteria for that. So if VCAT says, look, I think that the rent increase is justified, they'll just affirm the increase. So the reality is that if you make an application to VCAT and it's not successful for challenging, that's okay. Pardon me, a bit sick. All right, so this is what the rent increase form looks like. Now you'll see here under the method, the CPI, I've put it 1.1%. That's kind of a bit of a nonsense. So this notice to vacate itself could be invalid. One of the most important parts of the notice is towards the end. So at the end, it says, do you want to challenge this notice of rent increase? Check the box yes, don't send it back to the landlord. This goes off to Consumer Affairs Victoria, and then they'll contact you about making a time for the inspection. If for any reason your client loses this form, you can also access it online here and fill it in there. It's the same form that's used for repairs and rent assessments. So we know we've got 60 days, got to give us clear notice. We've looked at the method. This one's probably questionable. Now, how did your client get it? Did they get it via email? I need to ask, did you agree to get stuff via email? And then these are the factors that the Consumer Affairs Inspector will look at. They're the same factors that VCAT will also look at. This is the report that I made up. They are quite long. So they can take a little while to write up. We're aware that there can be a bit of a delay as well in getting these reports from the Consumer Affairs Inspector. If the rent increase is to take effect before you actually either get the report or before VCAT decides it, then you can pay the increase, and VCAT's got the power to refund you the difference if they find it that it's excessive or too much, or obviously you're going to have paid the right amount if they say, look, it's justified. So they go through all of the criteria in quite a lot of detail, and this is why it's so important for the renter to be able to point out, hey, actually, I made that improvement, or actually, here's all the repairs issues that I've been waiting ages for that to be done. So there's a lot of factors there, but particularly the one that is one of the big sways is actually looking online or talking to other real estate agents around how much properties are compared to. So it needs to be like for like, and it doesn't include comparing to social housing that's on, reduced rent. So they're really looking at going, okay, 3-bedroom brick, large open bedrooms, built in the 1970s versus the same. So once you've got that report, this is the part of the VCAT application. I want to challenge the rent increase, see the report. I'm seeking that the rent increase not be effective. Now you can obviously put more detail in there or provide more evidence. So even if the report says it's not excessive, a renter can still have a crack. They can still go and do their own research. They can go and look at that other information. And that's certainly something that we'd encourage people to do. But again, we understand that there's reasons that people might not be there. Now, the most important thing to understand with the rent increase framework is that it is not a circumstance or a test that gives any regard to the renter's hardship or personal circumstances. It is purely a market-based test, meaning it's looking at properties in similar location, it's looking at the house of how much it costs to run, repairs, it looks about any responsibilities that the landlord might have, it looks at any modifications. As I said, it's a bit vague, but generally it's if the landlord's made if the renter's made improvements, they shouldn't be considered. And they look at the number and the amount of increases. Now, this hasn't got a lot of attention. And in fact, there's not a lot of decisions about rent increase challenges, although we suspect there's been quite a lot of people challenging them. And that's why it's really important to know that if one renter challenges and is successful, that sends a beacon to a lot of other renters going, oh, well, actually, my rent went up that much. But it's not a percentage cap. There's no CPI cap. And again, I'm going to do something a little bit cheeky and drop out of the slides here and show you something else. Hopefully again, I'll get into trouble for doing this. So I'll just share this other screen here. So there was a old act in 1958 called the Landlord and Tenant Act, and this is section 64. And so there's been a lot of media around, rent increases, and there's huge amounts of literature about a rent increase and whether or not a fairness formula and again, there's lots of different meanings for all these things. Fairness formula, rent control versus rent cap. What does it all mean? And in fact, in my personal opinion, the 64 section here from 1958 was pretty thorough and probably more thorough than what we have now. But one of the interesting things is that the just being sort of a number of years after the war, they gave regard to the hardship of both parties, the personal circumstances of the landlord and of the renter. And they looked at the mortgage rates. They looked at all of these things in quite a lot of detail. They also looked again at the hardship in determining whether financial hardship would be caused to the lessee by increasing the fair rent for any premises. They can take into account the income of the renter, their family members, whole bunch of other things there that looked at people and human beings. And I just think that there's something very, very flavoursome to that. Sorry, I think I've shared the wrong screen. Anyway, I can send that around for people. I'm going to show it anyway because I think it's important that actually it's acknowledged. My apologies for this. It's such an important thing. No, it's not going to work. All right, I'll leave it there. I'll send it around. But anyway, it's such an important thing to recognize that that actually has happened. The sky didn't fall in. And I would really, really encourage people to be aware that in this dialogue, it's about humans. It's about what it does. So when you look at that consumer price index, you look at food, you look at all those things that are really having significant impacts on individuals, that we're aware of what that looks like. So at the end of the day, what's it all about? This is called an order. This is what you get out of VCAT if you end up going there. In one order, you might say the rent is excessive. And so they fix your rent and saying for 12 months, that's how much you're paying. The rental provider can't really do anything about it after that point. On the other hand, if the tribunal says it's not excessive, they say, look, this is how much you've got to pay. If you've overpaid extra money, they can refund it here as well. So as I said, if you make the challenge, it's not going to cost you anything further. The fee's gone up now, it's $70.10. So I'd really encourage you that if there's a person that thinks that it's too much, they should look at doing that challenge. But again, we know that a lot of people don't. So you can try and negotiate. You can talk to them and say, look, I'm a good renter. I look after your property, but I can't afford that. Do you want to keep me or not? And that can be a very frank conversation. You may want to seek financial counselling. So that could be an issue to follow up in terms of, do I want to seek financial counselling to work out, well, I've got a car debt, I've got, a number of credit cards that are all racking up. What can I do? If it's a choice between paying your rent and paying your utilities, pay your rent. Most of the utility companies will give you the opportunity to, enter into a payment plan, and providing you don't switch utility companies, that can go on for a very long time, and you're not going to get disconnected. Be aware of employment rights for your clients. There's a great community legal centre called JobWatch that can give some guidance, because that can be a really common issue. We've just seen some new legislation and changes around the gig economy. Try and make sure your client's fully aware of what their employment rights are. Centrelink is a major issue in terms of how long a Centrelink dispute takes to resolve versus rent arrears. So certainly just to be aware of doing that. Apologies. Yep. Okay. Sorry. Yep. I think my screen. Thank you for doing that here. Let me refix that. Sorry about that. Sorry, messed up the screens. So the contact details there are for JobWatch. Options if you can't afford a rent increase. What we're seeing a lot of people do is that a lot of people are actually introducing other people into their households. Some people are even putting themselves into situations of homelessness rather than having their reputation damaged. Just the next one, I think, after that one. Yeah, so that's a really big issue, is that a lot of people are so concerned, because a tenancy database listing lasts for 3 years. So if a tenancy database listing is put on there, which can be for rent arrears, that's a huge harm for someone being able to access. So a lot of people knowing that will actually put themselves into couch surfing or living with other family members and the like. So certainly something worth being aware of and being a little bit careful. So yeah, make sure that if someone's moving out, they give their 28 days notice. If they've lost their job, there might be circumstances where they can apply for what's called a reduction of fixed term tenancy. So that's a situation, just so we move to the title, which is moving out and preparing for next rental. It's one of the things that a lot of people will face in terms of job loss. It's certainly worth investigating what your options are before you just give the keys back. So if someone's on a fixed term contract, something's happened, we obviously want to try and preserve that. So one of the major issues for people in terms of when they get a notice to vacate, it might be for rent arrears. They don't have to move out by the termination date. That's probably number one. And the renter, if they're put on a tenancy database, if you're on a payment plan because you've been in rent arrears, you actually can't be put on a database for that. So it's only if you get a possession order for rent arrears, and it's also not automatic. If the renter knows that it's no longer financially viable, there might be some other options. And if person's really desperately looking for a place to live and they're just not able to afford it, going to VCAT when there's a possession order can give you up to extra 30 days before the eviction can take place. So there's some guaranteed extra time if you can show severe hardship. And the last thing to be careful of, particularly if people are bringing new people into their households, if they're putting them on the lease, is that they're jointly liable. What that means is if someone punches holes in all the walls and it ends up costing a few $100s, that few $100s or few $1,000s can be recovered from any individual. So if it's me, Deb and Karen, we're all on the lease and I'm the one that's done all the harm, but I've got no money, but Deb and Karen have got money, they can get the full amount out of them. And then it's up to us to sort out. And there's no easy place to sort of resolve those issues. So that's kind of the rent increase framework. It's far from a perfect system, and unfortunately, because the pressure is on the renter to do the challenge, it's really difficult to sort of to work out where the market is. So there really is, I think, a significant call for a change. We've been calling for a fairness formula. As I jig it up the slides a little bit, it's happened in the past and it's worked reasonably well. And I don't know historically why we lost it. But I think we're giving regard for the human beings and the homes that we have is an important legal consideration, because that's what we're facing now. We're facing a rental crisis, an affordability crisis, not just for housing, but in terms of the way we live. So yeah, that's pretty much it. There's some resources at the end about the sections, the ability to challenge. Our contact details are at the end of the slides as well, but I'm really happy to take any questions that you've got now or from the group. And I think I've lost permission to share slides. So there we go. Thanks.
Fantastic. Thank you so much, Ben. It's Deb speaking. Your subject matter expertise is so impressive, Ben. We're really fortunate to have you involved with these events. I just want to say, as kind of the MC or host of this event, my head is kind of spinning with all the information. There is so much to kind of take in. You've stepped us through it in a really great way. I just wanted to emphasize we're going to open up for some questions now, but we will share that slide deck with people as well, Ben, because there's a lot to kind of take in.
Yeah, of course.
So thanks so much for all the material that you pulled together for us. So just a reminder to pop your questions into the Q&A box at the bottom of the screen, and we'll get stuck into questions now. So the first question is, Ben, you spoke about rent increases being provided in the right way. Can you please tell us how renters can prove a notice was not delivered in the right way?
Sure. So when it comes down to proof, usually it will be something that the tribunal will ultimately decide. So, for example, a rental provider might say, "Oh, I sent it to the post." This is sort of the common one because it's not tracked. Now, part of the framework of any legal dispute is about who bears what's called the burden of proof. So if it's my application, generally I'm the one that has to prove it. So in a situation where the rental provider is asserting, "I sent this document, so I've justified the increase," the tribunal would expect the rental provider to be able to prove that they had sent it. What can happen, and I think that sometimes is misconceived on behalf of renters, is they go, "Oh, I'm not going to collect it," or I never, I never got it. And once the rental provider has shown that they sent it, it's up then to the renter to prove that they didn't get it or weren't able to get it. So not collecting it down at the post office is not going to be justification. The law has what we call deemed service, which says, well, you could have collected it, and I'm inferring that you had the opportunity to collect it. And the same thing can happen with email, where people say, well, I sent it from my email, here's the outbox, but then for some reason on the other side, it may not have gone through to the server. And there are circumstances where the tribunal will say, well, look, I can see that there's nothing that the tenant could have controlled to say that actually they got that. So in each situation, it might be factual. That's why often rent increases will be via registered post or electronically. If a renter has given consent to receiving documents electronically, they can actually revoke that consent at any time. We've seen some rental agreements where they'll say, yep, it's all pre-filled in. Yes, you will be accepting electronic service, but you can withdraw that as long as it's withdrawn in writing. And personally, I'm terrible at my personal email. I hate looking at my personal emails. So I like getting something in the post. It gives me a bit more time, but it's just that physical reminder. And I think for a lot of our clients where life is chaotic, it's very easy to forget about an email when you're busy. Whereas if it's, on the kitchen bench, you're like, oh yeah, I'm going to deal with that, because we really do only have 30 days. There are exceptional circumstances where you might be able to get more time, but the process to do that is quite complicated. So acting quickly is really important. Yep. Hopefully that answers the question.
Thanks so much, Ben. The next question is just a reminder around, can you remind us how often the rent can be increased?
Mm-hmm.
I don't think we can remind people too many times.
Sure. Yeah, no worries.
In
So
2021.
the increases can be done once every 12 months. So that's for when it takes effect. So the notice might potentially be given a bit earlier, but it's actually for when the rent increase takes effect. There's actually no framework around withdrawal of it either, which is a really interesting issue, because you sort of get some people go, oh well, I sent the rent increase, now I'm withdrawing it, but I don't think there's actually any provision for it to be withdrawn. So the idea of, well, you had your chance, it was too much, you've done. So we haven't actually seen any decisions like that. But the only exception, as I said, is that if someone's continually been a periodic tenant in the same tenancy since June 2019, they might be every 6 months. But again, it's still a relative test of increases over a period of time. So it's really just an opportunity for the landlord to jump up again. But I think that, as I said, there's a lot of anxiety for rental providers, particularly at the moment, to try and increase as much as they can to guard themselves against the future financial events of whether it's mortgage interest rates or simply being greedy. Who knows? Yeah.
Yeah, great. Thank you. And we have had a question just on that as well. Someone in the audience asking if a renter is on a month-to-month
Mm-hmm.
lease,
Yep.
would the landlord be able to increase the rent every 6 months?
No. So it's regardless of whether you're fixed term or periodic agreement, it's still the 12 months. In fact, the fixed term really should, in most cases, actually protect and lock your rent in for that amount. There is a provision under Section 44 which talks about the actual rental agreement having a built-in increase, but any increase should be accompanied by that notice of increase. So if the new rental agreement had an increase and there was a built-in rent increase, I would call invalid on that. Sometimes we just don't know, and that's why we need to get into the tribunal. And as I said, there's really not a huge body of law that you would expect to be in from the tribunal about rent increases. So that's why we kind of need the champion renters. But you're sticking your head out a bit, but it can make a massive difference. So certainly those matters where they challenged on the method, I'd call them champions. I think they did a great job, because it was sitting there just going, well, what does that actually mean? It's not defined in the law anywhere.
Yep, great. Thank you. You mentioned people might like to bring housemates in to share the costs. Can
Mhm.
you get someone in and not put them on the lease?
You can. You need to be very careful. So Tenants Victoria got caught up into subleasing. So to sublease to someone else, you need the written consent. So that was where you effectively become the landlord and they don't. Now, not all situations where you have a guest living in your house will necessarily be a subtenant. They can be what we call a licensee or a boarder. So they're not in the agreement. But equally, if I'm your subtenant and I come in and smash all the place up, I'm your visitor and you're liable for it. Woo! So not that I'm going to do that. But I think the challenge there is about sort of responsibility, and also you need to be very careful because we do see some entrepreneurial inclined people to in fact try and do that with multiple rooms and end up running a rooming house. So we're running a rooming house trading session, I think next week maybe, not to run a rooming house for residents, but essentially a rooming house is where you've got one or more rooms and they're occupied by four or more people, and one person controls who moves into each of those rooms. So whether or not they're on a written agreement or not, just by virtue of each person having a room, or not even each person having a room, but four people living there sort of on separate agreements, you can actually end up being in a rooming house. And it's quite a serious offence to be running one because you need to be licensed, it's got to be registered with council, a whole bunch of other stuff. So you do need to be very careful in terms of, if you're thinking you're being sneaky, of going, oh, I'm just going to bring as many people as I want into my house. But on the other hand, like if you're a family and you've got children and got a massive family, that's fine. But it's different from bringing strangers in and out, sort of running it as a bit of a a rooming house. So yeah, not everyone has to be on the lease, but you need to realise your potentially exposed liability. If you're going to do subleasing, you need to get the written consent of the landlord, and you need to understand that you would effectively become like the landlord. Well, you would be the landlord to that person. There's quite a lot of consequences, and there's a big service gap. Like Tenants Victoria generally won't advise a head tenant in relation to doing that. But we certainly do see a lot of people. There's even a trend of what's called hot bedding, where people go, well, I'm doing night shift, you're doing day shift, we'll just share the same bed, because that's what people are looking for. It's not great, but everyone needs a home. So yeah, I'm not sure if a hot bed constitutes a home. I think it should still fall into the definition of homelessness. I'm not sure. Yeah.
Yeah, and I guess with that, Ben, like our kind of, my reflection on that would be as well is that we're providing these information sessions to make sure that community sector workers are aware of, what the laws are, how to interpret those laws, what some of the unintended kind of risks of different decisions kind of give rise to. But this is all kind of set against a broader backdrop of the work that Tenants Victoria and VCOS does in terms of engaging these issues, in terms of our policy development work and our systemic advocacy as well. But just in regard to that session that you mentioned that's coming up around rooming houses, post this event, we'll also share that Tenants Victoria event for people as well. So thank you, Ben. A lot to kind of get our heads around, really, which is why we run these events. You mentioned about getting people into VCAT. Do you know the wait time for VCAT at the moment? And would this also give someone more time if there's a waiting period for the application?
Yeah, look, the law, at least for the residential tenancy, like just your normal tenancy sort of stuff, not rooming houses and other jurisdictions, there's no formal requirement that the renter has to pay the increase. But if the increase was to take effect and you waited 4 months and then it was decided it would be valid, you'd automatically have this huge whacker of rent arrears. So it's really a way of safeguarding yourself to do that. In terms of wait times, the VCAT listings will vary throughout the regions. We know that there are some types of applications like bond and compensation claims where people are reported waiting almost 12 months, where there are other circumstances where there's a mandatory listing time like urgent repairs and they get in with 2 business days. In this framework for the rent increase challenge itself, I don't believe there is actually a listing time requirement. I would be expecting that it could be well over a month for some people once they've sort of got their CRV report put in their application and been waiting. So I suspect there will be quite a number of people going, well, what do I do? Do I pay the increase? So in the rooming house environment, you actually pay 110% of your rent increase, or the actual increase, whichever one's less. So there's a bit of a guard of almost an implicit 10% test there, but we've seen that a lot of the jumps that people have had are quite significant. And that's one of the major issues that we do see in the rent increase space, is that you might have an elderly person who's had really nice, elderly generation boomers that have paid it off and go, I'm not really interested in charging huge amounts of rent. Then that parent dies, the kids inherit and go, right, we're going to jack it up. And because it's a market-based test, you go from, I'm going to be very sort of colloquial in this, Nana Beryl paying, $300 a week up to Nana Beryl paying $650 a week in one increase. And in fact, it's not a percentage measured test. Like, as I said, there's a little bit about that, but actually that could be a valid increase because it's just bringing it up to the market test. And we see a huge number of elderly persons and other persons as well exposed to that, absolutely terrified of just going, I'm elderly, I'm not competitive in the market. How in goodness name, if I lose this property, will I be able to survive? And I think that that's a really important call for the government, a responsibility for all of us. We've seen huge numbers of people use their superannuation. In the COVID pandemic, there are a lot of what I would describe as ticking time bombs of economic sensibility about how we respond to the current climate and housing provision. Yeah.
Yeah, and not that we need it, Ben, but like a reminder of like what drives us, our work in the sector, our organisations. So just to clarify as well, so another question that's come in is very specifically, can your rent be paused while you challenge it?
There's no mechanism specifically to allow you to do it. There are unusual circumstances where someone might be they're called interlocutory injunctions, which is essentially going, well, I wanted to have my hearing, but I think if you're going to get a quick hearing like that, you may as well get the rent increase matter determined anyway. So it might be a bit of a question of squeaky wheel gets the grease. What we suspect may happen in some of those circumstances, in fact, is that the increase might take effect. The landlord alleges, well, it's taken effect, VCAT hasn't decided, we're going to give you a notice to vacate for rent arrears, and then you end up having the rent arrears matter and the rent increase matter heard concurrently. As I said, it's really important that renters understand if they get that notice to vacate for alleged rent arrears, just seek advice straight away, jump onto us. I think probably, Deb, as you're saying, there's so much information here that can be really overwhelming. When in doubt, just give us a call. We really want to hear from community workers. As Deb said, you guys so understand the real journey of what's going on for people, and you've travelled alongside with them, and that is a very powerful voice. It is a powerful story to know how this system is harming people, because in the long run, that's actually going to cost the state a lot of money. People that are not travelling well, do not work well, do not contribute to society well when they're so stressed about trying to survive. So yeah, you guys are such an important part of what we do.
Yeah, and in that vein, Ben, of like really trying to kind of like embed the knowledge and kind of wrap our
Mm.
heads around this. Even though you covered it at the start of the presentation, just a question to help us embed that knowledge is if you could just reiterate what the law says in terms of how much can the rental provider increase the rent by, just
Sure.
helping people get
Sure,
their
sure. There is no cap. There is no cap. So it means that when we say there is no cap, it means that there's no limit whatsoever about how much a rental provider can increase. It's only a relative test that can be realized. So Consumer Affairs will make a recommendation based on what it thinks, but ultimately it's going to be up to the renter to go to VCAT and say, I think it's too much. And if the tribunal says, yes, it is, then it gets locked in. So it is a really, really difficult system in the sense that, wouldn't it be wonderful, if there was a system where, hey, rental provider, you can't increase your rent until you do your repairs, or hey, rental provider, the place that you've got here, you need to do some other work, so before you can actually justify the increase. Yeah, so there are other options, but we do need, I guess, a legitimate reason, and a lot of that is the politics of, is it going to be too expensive for a rental provider where they choose to exit the market? I mean, the houses don't disappear. Either someone buys it, ends up becoming their home, but what we need is for it to be affordable and it to be accessible and it to be, benchmark that, when the generation grows up, that house is going to be secure for them, and that the youth, particularly, who I feel will have a huge amount of anxiety at the moment, going, I can afford rent, let alone buying a house.
Thank you, Ben. A question that's come in, people wanting to know a bit more about the CAV process, or we
Sure.
often use like acronyms or jargon, so
Yeah, yeah,
CAV being
sure.
Consumer
Yeah,
Affairs
yeah.
Victoria. So how does Consumer Affairs Victoria calculate or verify whether a rent increase is fair or not?
I think the method is pretty loose. And I think that there's probably a little bit of room for scrutiny about this, is that when you get a Consumer Affairs report saying, yes, this is definitely valid, or this is definitely not to be so mentally locked in to say that that's the end of the road. If a renter can go and do their own research, as I said, there's a lot of data out there. Like if they say it's not excessive, and you can go and pull 3 other properties off Domain or realestateagent.com that go, actually, here they are, there are cheaper ones out there, then go for it. A lot of the time it's really about the renter. So that methodology, the example letter that you'll get in the slides there, it really does look exactly like that. They go through the legislative criteria and they sort of say, well, these are the things that I can look at. So that's why I also would strongly recommend that you actually are there when the report's done, so you can actually walk them through all those details that someone in a quick walkthrough won't necessarily spot or see. They may not spot the rising damp that's, coming up the side of the wall behind the wall, yeah.
Thank you. And just revisiting the topic of bringing people in to share costs, which we know is kind
Yeah.
of increasingly happening in kind of this global cost of living crisis, which is hitting hard locally.
Yeah.
The question is related to agents, landlords charging admin fees to
Sure.
add new names on the lease. And
Yeah.
someone is saying, my son had this situation, they wanted $200. Can
Yeah.
you tell us a bit more about
Sure,
this,
sure.
please?
So legally, transferring people on and off a lease is called assignment. Sometimes there's a form from the Residential Tenancy Bond Authority, which is called a tenant transfer form. The relevant sections are 81 through to 84 of the Residential Tenancy Act. What it says is that the landlord can't unreasonably withhold consent. So you might have 3 people and be adding a fourth, or you might have 3 people and one person leaves and you replace it with another person, so you still end up with 3. But if you're adding an additional person, if the landlord gives written consent, everyone fills in that form, it changes over. The law says they can't charge for the giving of the consent. What they can charge for is the administration of doing the thing, which really is just signing the transfer form. Some do a little bit more than that. But other than that, we suggest that the amount should be charged as probably about $130, $140-ish. That's based on a very old decision now. It's almost 13 years old, called JUP. And yeah, it was just really about sort of the cost of doing that form. So $200 seems a bit on the high side. We've seen outrageous ones of $600 per person as a way of just trying to make money out of very, very little work. So if people pay too much, they might be able to apply to get a refund. Probably the most important thing when you're talking assignments or transferring on and on the lease, like particularly if you've got a kid that's doing it, is to realize that when someone gets transferred onto a rental agreement, they're inheriting the liability for that property as if they were there since the very beginning. So if you move in and the house was all great on the condition report, I'm a really bad renter again, smash all the house up and then transfer you and go, oh, it was always like that. And then it comes to the end of tenancy, whoever replaces me will end up getting stuck for all the costs. So you always want to make sure when you're going into a property that you look at the condition report very carefully, you make sure there's no other issues there. If the rental provider does refuse the consent or just ignores you and you really want to do it, you can actually apply to VCAT to force them to take the people that you want to put on there.
Great, thanks. I think we've got time for one more question. So this is, the question is, my client successfully challenged their rent increase.
Great.
They had their rental payments added to their ledger, which reduced their arrears. Unfortunately, the agent has now issued a new rent increase and has provided the comparative market analysis. Is this sufficient?
Well, it sounds a bit suspicious. If they've challenged before and was successful, it should be another 12 months before that swings around. If it has been the 12-month cycle, it's going to be a relative measure. So the tribunal's obviously benchmarked it at this point of saying, yep, that looks like again, bear in mind here that there's no decrease framework. There is a slight mention in Section 44 of the landlord withdraws services. So you might actually, have a property that's not separately metered, and then they make it separately metered, so you end up paying for utilities. So you could actually ask for an increase, but a decrease in your rent. But that's very, very rare, and the process isn't very clearly set out. But in most situations, when you're facing those increases, you really want to make sure that looking at the CAV report and getting in there. So this is a good example of probably calling us so we could look at the pattern of when the increase was given and say, yep, okay, it has been 12 months since, or actually it hasn't. Because as I said, if it's like 11 months and 15 days and the increase is going to kick in 11 months and 15 days, not valid. So yeah, it might be a good one to just jump on the line and have a chat through with what you got.
Yeah. Now we're about to wrap up. I might just say I noticed that there was a question earlier in the chat, which is it's really a policy question about the consequences of a government imposed freeze on rent increases, and the person asking if there's fear in the sector about kind of unintended consequences of that in terms of supply.
Yep.
Just to say that I guess the presentation today is really focused on the current laws. There are obviously live conversations around what do future ways of rent regulation look like. From VCO's perspective, rent freezes is not something that we've been kind of advocating for, but we've got very kind of nuanced positions, and we might kind of share links to Tenants Victoria's submission to the recent parliamentary inquiry on rental and housing affordability, as well as the VCOS one, where people can get a bit more stuck into the detail around the different forms of rent regulation that people are talking about right now. But it's been great to kind of engage with today, Ben, with you around the kind of the current settings. Knowing that we kind of need to kind of be pushing for, as well as embedding the current reforms and allowing or helping people to assert their existing rights. What's the next wave of rental fairness kind of reform look like? So thank you so much. A big thank you to you, Ben, our guest presenter. Please check out the Tenants Victoria website, everyone, for lots of information about renters' rights and supports. Both those resources are both available for renters and for community sector workers. Really just want to say thank you as well to the Department of Government Services and the Victorian Property Fund. Our Renters' Rights Rundown events are made possible with their support, so thank you. I want to thank all of our attendees for your attendance at this event and other events. VCOS member organisations, this engagement is so important in terms of us, the important work that we do together, and your insights really help shape our sector communications and our policy development work on Victoria's rental rules. Really want to also give a big shout out to the VCOS team, to Karen Taranto, our policy guru, and also to Amy Houston, who just provides such great communications and event support to us. A reminder to just please take a few moments to complete the event survey when it pops up on your screen in a moment to help us plan future events. So it's very different to the survey that we popped up at the beginning of the session today. Full transcript, caption video recording of the event will be available in a few days. We'll send you a link to those resources where they'll sit on the VCOS Renters' Rights webpage, where you'll find everything that you need. We'll also chase up those questions we didn't get to today. So please keep following us on social media, sign up to our email alerts to learn about future events like this one. And thank you so much for joining us today. I hope you have a great afternoon. Thank you. Bye.